Welcome to Influential Entrepreneurs, bringing you interviews with elite business leaders and experts, sharing tips and strategies for elevating your business to the next level. Here's your host, Mike Saunders.
Hello and welcome to this episode of Influential Entrepreneurs. This is Mike Saunders, the Authority Positioning Coach. Today we have with us Randi Karpinia, who's the CEO of Sagacity Legal, and we'll be talking about patenting an invention. Randi, welcome to the program.
Thank you. It's a pleasure to be here.
Yes, I want to learn all about patenting an invention, and I'm sure we can cover that in just, one quick conversation. I'm sure this is just a big topic. So that's one thing that I want to really just dive into is just little sections here and just make sure that we clarify each and every point. So when you think about, or when you work with a client about patenting an invention, what's the first place that you're starting with in the conversation with a client?
That is such a good question. People come up with these phenomenal ideas, and at first they're just super excited. And in fact, by the time they come to me to ask about a patent, they've probably had the idea for a little while because they haven't listened to your podcast yet. So they didn't know all the do's and don'ts and processes, and patenting sounds very legalese. So when people first come to me, the first thing I try to talk to them about is the need to stop sharing. And that sounds almost counterintuitive. But when you have this phenomenal idea, you want to tell everybody. You want everybody to share in how excited you are about whatever it is you've invented, whether it's, a new product that makes life easier or, some kind of methodology that you implement in software. You just want to tell everyone. So one of the first things that I always talk to people about is, who have you spoken to about this and how much have you divulged? And that's can be kind of a mindset discussion because people don't want to keep their ideas a secret.
Yeah. Because it comes up in conversation. It's like they've probably been vetting the concept with, their inner circle, friends, family kind of a thing. But there's a point where you can get too detailed and then maybe it's crossing a line where maybe, someone else goes, well, I'm running with that. You've heard that horror story out there.
Yeah. And there's actually, it's funny. There's people always think about the copycat, but there's actually I'm going to put it into three buckets. So the first is what you said, is you tell somebody about your idea and they might not even remember where they heard it, but then they elaborate in their mind and at some point start developing it themselves. Well, one of the little known facts is in many of the patent offices around the world, and specifically in the U.S. Patent Office, the first to file the patent application is presumed to be the inventor. So what that means is in the non-copying case, where, for example, someone in California and someone in New York happen to just get the same aha moment at similar time, the first one wins the race to the patent office. They get the patent, you don't. And that can happen. If somebody, quote, steals your idea, there is a way, like legally, to question it and tell the patent office, hey, they stole that from me, but proving it and the legal process that goes into that is very confusing and very expensive.
So
the other thing that people, go ahead.
I was going to just mention one thing that from an uneducated third party like myself, I've heard this out there. So you can correct me if I'm wrong. If you have an idea for something and you want to kind of mark a line in the sand and go, this is mine, write it out on a piece of paper, mail it to yourself, because then that stamp that, gets a government stamp, federal stamp, now you don't open it, but if anything comes up, you can go, look, this is my idea and this is proof in the timestamp. Is there any validity to that at all?
There's none, and I've heard that
like an old wives' tale.
So many times.
Right.
It actually had some validity. So before 2011, the U.S. Patent Office used to have what was called a first to invent system. What that meant is if you could prove that you invented it first, then you could kick out whoever filed first.
Okay.
But see how different that is from what I explained? They changed revamped the entire patent regulations in the U.S. and went to a first to file. So now it's tricky, but it really doesn't matter if you came up with the idea first. The person that files first wins.
Yeah, that's great. Okay, so then
which makes keeping it quiet.
How do you make sure that you keep it quiet? Because, like you said, you might have been chatting it up, and then you hear Randy tell you, well, you need to keep it quiet, and you're like, well, shoot, I've been kind of, testing the waters and telling people, getting their feedback. They might have let the cat out of the bag, but if someone hears this ahead of time, what are some ways to make sure they keep it quiet until you're ready to file?
Great question. So the first is, really not over drinks at, your favorite bar, no discussions. The people that you share your idea with should be select few who you really trust implicitly. Maybe it's family members or maybe not. And then when you are working with others, it could be potential investors, manufacturers, employees, consultants. Make sure before you disclose your idea that you have a really good confidentiality agreement. With my clients, with my inventors, I actually call it an IP NDA because within the non-disclosure agreement, I include things that say, I'm sharing my idea with you, and you know that it's mine and you will not take it. So I actually put that into the agreement.
And then in that agreement, are you mentioning some of the details about the idea or keeping it vague?
Keeping it vague, because what if they don't sign the agreement?
Yeah, but okay,
right.
Great point. But what if the agreement is so vague, then they signed it, and then they went and took it, and then you said, "Look, you signed this," and it's like, "Well, you told me verbally, X, but I went out and patented Y." There's no proof that you were talking to them or meaning that thing. So I'm just kind of putting on devil's advocate hat.
And it's an excellent point. And so this is the balance of how do I protect my idea but still talk to other people about it. So there's a third thing that you can do, and that is you can file what's called a provisional patent application. Okay. So remember we talked about the first to file is presume the inventor. So file what's called a provisional patent application, even if you're not fully cooked with your invention, prior to having those conversations. Okay. It puts a stake in the ground. It's mine. If that person comes in behind you, like you said, and says, no, I submitted Y, well, you have the earlier date.
Yep. And you had that broad IP NDA that they signed, and they could say, no, you told me this. And you're like, really? Because look at this filing right here. I already filed a provisional, and you caught them in the act there. So that's a really good point, that provisional. Good. Yeah. Okay, so here's a question. How do you know if something is even patentable at all? Because I would suspect that there's some things that people come to you and like, oh, here's my thing. And you're like, ooh, you spent a lot of time on this, haven't you? But you can't patent this because.
Great question. A lot of people think that the Google sphere is everything, right? So when they come to me, they say, I'm a consumer of this and I know it doesn't exist. Because I've Googled it, I've talked to everyone I know who's also a consumer of this. It doesn't exist. I know it is. But here's the problem. People patent things all the time around the world without ever actually making the product. In fact, in the U.S. alone, they're in the 11 million numbers. So there's over 11 million U.S. granted patents today. And so many times, the idea itself may not exist in the market, on Google, in the stores, but there's either a single patent or a combination of patents that would make yours not patentable.
Okay, so that's an interesting point. And so I want to make a correlation and see if this is very similar. Because what you just said is, here's these people that have this patent for this thing, and they might not have taken it public or shouted from the rooftops about it, but it still is patented. And maybe it might even be, person A and person B, have this agreement. They're doing manufacturing together and they're just cranking out these widgets. And here's the person who came up with the idea and they have a patent on it, but they don't need to go to Google and create websites and programs because they know that the friend down the road, that's the, manufacturing warehouse, they're just doing it. And they just need the patent for protection, but it's not public and visible. Is that a good way to think of it like that? So just that quick Google search isn't the best way for you to go, yay, something's available.
Exactly.
Yeah.
Yeah. The first, when an inventor comes to me with their idea, so some attorneys, some law firms, and it's a way they, someone says, can you patent this for me? And the firm gets to work writing the patent. I don't do that. I always put my inventors on hold and say, we need to do what I call a patent search and legal opinion.
Okay.
So I need to, my team and I literally go through worldwide, not just the 11 million in the U.S., but all over the world, and figure out what's the closest patents that already exist or published patent applications. And then we come back to the inventor and say, you know what? You gave me this broad product. It's super cool. But only this piece is patentable, and that's what we're going to file an application on. Or I'm really, really sorry to tell you, but in actuality, nothing's patentable.
Yeah. And it's similar. It makes me think of like when I watch Shark Tank every single episode, and you hear, people or Lori or whoever going, do you have a patent on this? And I'm like, we have a utility patent on the way that this connects to a that with rubber. And it's like, wow, that is so specific. But maybe that specific product there, they did a search and it's like, ooh, the broad use of this thing is patented already. But if you wanted to patent the connection of this to that and the other, then you can go that way and still move forward. Is that kind of how that would work?
That's exactly correct. So, if you think about the bigger companies, that name brands that we all know, they have thousands and tens of thousands of patents, and each one of them is one little piece that adds up to their product. Just think of your phone, your computer, whatever. All those companies have many, many multiple patents on one specific piece of the puzzle. So when a new, say an entrepreneur or a new startup comes around, we're going to find that piece. And then over time, hopefully and theoretically, we will find more and more of those pieces and they will multiply their portfolio, but they will be individual concepts.
Isn't that similar to if you have a company called widgetsusa.com and you buy the .com? So widgetsusa.com. People will say, make sure you buy widgetsusa.net, .org, .info, everything else because you want to protect that. Well, when you're talking about patents, what if you got a patent on your widget? How many variations or future applications, how many do you need as the inventor need to have in place to potentially protect someone from coming in and going, oh, that's fine that you're doing it this way. We're going to patent the application of your thing, but this way. Is there a way to kind of build a moat around your idea that way?
Mm-hmm. And patent strategy is all about going as broad as you can and as narrow as you can. It's so tricky, and in this short conversation, I can only just give you like kind of an overview. But so the claims of a patent are what you own, and when an attorney is just determining the claims, they can't go too broad. We talked about that, right? Because then there's all those other patents out there. Yep. But if they go too narrow, then someone can go, well, you're A plus B plus C. I'm going to do A plus B plus C. Haha, I'm not infringing.
Right.
So it's very strategic, and it's almost a tightrope walk between too broad, you won't get the patent, and too narrow, and you're just not protecting the product, right?
Because if you go too narrow, you might get that patent, and that's great because the patent office looks at it and goes, yep, you're in the clear because you went so narrow. But someone else could come along and go, wow, that was such a great idea of your thing, whatever this thing is. We have this cool iteration or innovation of it, and we're going to patent this thing. And now all of a sudden it's a bigger company that can throw more dollars at it, and it just kind of blows you away. So it kind of goes both ways. When you're looking at how to not infringe on someone else's patent, do a search. But maybe if your search comes back and says it's something similar to that is in place, but it's using it this way, maybe there's a way that you still can move forward. So I think what I'm hearing you say is make sure that your patent idea is not already in place or a version of it, and then assess what you need to do from there because you don't want to infringe on someone else because it's an exercise in futility. They're going to either deny it or come back on you legally.
Yes, and infringement, I was looking at numbers today. If you get sued for patent infringement, you're going to theoretically lose every bit, especially if you're a startup, every bit of that capital, of that profits that you started earning just in legal fees. It's millions and millions of dollars just to litigate a patent infringement lawsuit. And the awards can be in the hundreds of millions of dollars or billions. I mean, we're not talking pennies here.
Yeah.
So knowing up front, and then, knowing up front not only what is patentable, but what else is already patented, not only in the strategy to protect your own invention, but to protect you and your business from somebody else coming after you. Because
it's not just a slap on the wrist.
Absolutely not.
Yeah.
It's huge, huge money, and unfortunately it's a big industry. These patent infringement people who, which goes back to when we talked about there are a lot of patents that are not in product because there's actually companies that just patent just to enforce. They're called non-practicing entities. They're not actually bringing a product to market.
Yeah. Okay, so it makes me think, oh my word, hearing all of this, and you got to go so deep in so many layers of patents to protect my thing, my idea, my service, my product, whatever it is. Is it even worth it? Because, man, I'm going to spend huge amounts of money to get 19 variations of it patented. And then if some big corporation comes along, they could squash me. And even if they come and infringe on it, I don't have the means to fight them on that, even if it is an actual infringement. So what do you say to a client that says, is it even worth it?
Oh, gosh, that's a good question. Because, I'm always going to say it's worth it because that's what I do for a living.
Yeah.
If you really believe in your invention, your product, your service, your system, whatever it may be, and if there is the ability to protect it and patent it, there is so much value, and it is a value versus risk. But as an example, my clients that I work with, that many of them do, they start with one and now they're up to 5 or 10 or whatever it might be. Patents are, just like all intellectual property, are an asset, are an intangible asset to your company. So what does that mean? That means if you need investors, like on Shark Tank, right?
Yeah.
Do you have a patent? Investors, bank loans, anything that includes a valuation of your company, having intellectual property assets, especially having patents or even just patent applications, is a huge value boost for your company.
It also would be a competitive advantage, even just in your sales and marketing, right? Like if you were selling your idea of whatever, and it's just a great idea, that's not going to be as strong as this is our product and it's patented. So it becomes a marketing competitive advantage. as well as investors and value to the company and valuation. We want to sell our company, so we have this patent. So all of it has value even day one, day two, once the patent is issued. So last question, and it makes me think of this just as a newbie hearing this: is there any value in patent pending? Like, patent pending means it's in process and it isn't issued yet, but is there any value from the intrinsic thing we just were saying, like from a competitive advantage standpoint? Does patent pending really bring any juice until the patent's, executed and issued?
That's a good question. Yeah, patent pending, you can actually use a patent application. Of course, an investor or a bank would look at would actually look at the document, would look at the patent application. But patent pending can buy you almost as much value. And as you said, from a marketing standpoint, you probably see it all the time. Patent pending is not only a no trespassing to your competitors, but it adds clout to the technical capabilities of your company. So
you could have a small fry competitor that's like, ooh, I guess we better not this patent pending, and it could have a bit of marketing clout, but also it gives you something to talk about now, patent pending, but also when the patent is issued, it gives you a marketing PR public relations campaign to say it was issued. Take a look, so it gives more and more excuses in a good way to talk about your company. So I think that's another benefit too.
Absolutely. Well, if you're going to be competitive in 2022, you need to be protecting your inventions.
Yes. Well, to get your idea, at least started or off the ground, or the patent conversation started, if someone is interested in connecting with you, how can they learn more about this and reach out and connect with you, Randi?
Oh, thanks for asking. So I make it really easy. If someone wants to set up a conversation with me, they literally go to meetwithrandi.com and they can get on my calendar. I make it very easy, and we can have a chat about strategies and more about this discussion. And I do that freely because I like to teach and share. And then if they just want to read or learn more, sagacitylegal.com is my website, and I have a blog there. And if they don't like to read and would rather watch videos or listen, my YouTube channel is Attorney Randi Karpinia. And all of those are ways that they can learn more.
Awesome. Well, Randi, thank you so much for coming on. It was a real pleasure talking with you today.
Thank you so much. Great questions.
You've been listening to Influential Entrepreneurs with Mike Saunders. To learn more about the resources mentioned on today's show or listen to past episodes, visit www.influentialentrepreneurssradio.com.